My name is Chien. For those of you I haven't met, I'm thrilled to get to meet you today. I'm the Executive Director of Berkeley Law School's Criminal Law and Justice Center. We have an amazing team of hosts and co-hosts today, and I just want to acknowledge all of the hard work that has and will go into making today a success. Our main partner in this symposium is the Berkeley Journal of Criminal Law. We have a huge team, including both co-editors-in-chief working with us today, moderating panels and more. Also a thank you to the Paper Prisons Project, another one of our co-hosts. A very special thank you to our law firm sponsor, Kecker, Van Nest, and Peters, for helping make sure we have delicious food for everybody at no cost. A huge team of UC Berkeley student volunteers are helping us throughout the day. And of course, I want to thank and acknowledge the team at International House that's hosting us and catering the food, as well as Tony Mendocino, who has made all things possible with this symposium. We have over 500 people who RSVP'd, and just for context, when we envisaged this idea, we thought maybe we'd have 100 or 150. So it doesn't feel like there's 500 people in the room. There's going to be at least 200 people joining us virtually, and people will be coming throughout the day. I'm sure the rain has slowed some of them down. It's not just the number of people, it's the diversity of people. As I looked over the RSVP list in preparation for this morning, I noticed representation from more than half the public defender's offices in the state, plus a huge array of other public service defense side law groups and appellate projects. Our hope was and is to create a forum, a symposium for people on the front lines of the Racial Justice Act to share information, lessons learned, pitfalls to avoid, to strategize informally, and to learn from experts in the field. And we have an amazing lineup today. I'm so thrilled, and I want to thank all of our speakers for agreeing to speak, for coming to join us today. And I know all of us are particularly excited to hear this evening from Assemblymember Clara, who wrote the Racial Justice Act and who continues to carry cleanup legislation year after year, and who I'm sure will benefit from hearing from all of you as well. In just a minute or two, we are going to kick off with our first panel. But before we do that, we are honored to have a few words in just a couple of minutes from the Dean of Berkeley Law School, Erwin Chemerinsky. He'll be joining us in probably the next 2 minutes. He's someone who really doesn't need an introduction. He's a force of nature. He's probably the only law school dean in America who is universally loved by not only professors who work in his law school, but students and administrative staff and people in general, even when they disagree with his ideas or views on a particular issue. He is a force of nature, arguing cases in circuit courts across the country, continuing to teach, even though he's running the law school. At the same time, advocating for his students to get clerkships, advocating for the budget of the law school, and generally doing all things for all people, which is why we know that he'll be here almost exactly at 8:33. So I'm filibustering just a little bit, but we've all been in that position as public defenders with a witness that hasn't showed up and trying to make it to the lunch break before the judge tells us we've got to rest our case. And maybe that's the situation we're in right now. So I appreciate your indulgence. You've all been there before. What I'll do while we wait just another minute for Erwin to get here is I'll just say the first panel that we're going to kick off with is one of my colleagues here at the law school, Colleen Chien, and she'll introduce herself, but it's a team of students that she's worked with and professors that she's worked with to develop a Racial Justice Act data tool. I know we're going to be hearing later in the day after lunch from another panel of data experts, and we all have a lot to learn about the data and how we can better use the data and better work with experts. So that's why we have 2 panels, including the one in just a moment, focusing on data. And the moderator of this first panel, who I'll be introducing, or who will come up after Erwin has a chance to speak, is Alex McLennan, who's one of the co-editors-in-chief of the Berkeley Journal of Criminal Law. One of the other things, just as an FYI for folks, CLE credits are available, including implicit bias. You can scan the QR codes on your table. That will take you to a page where you can register for CLE credit. If you want Wi-Fi, there is Berkeley open guest Wi-Fi. You don't need a password. You just connect and then click click the box to accept the terms. It will let you on Wi-Fi. There are restrooms across the hall. If you need the law school for any reason, it's just across the street. But all of our activities today are going to be in this room. For lunch, we don't have separate spaces for formal breakout rooms. But what we might do is encourage people who are focused on specific topics to gather in different corners of this room. And I know there had been some conversation about breakfast tomorrow. We don't have a physical space available to convene this big a group, but we are encouraging people to informally network and arrange to get breakfast to continue the conversation tomorrow. And without further ado, I've already introduced him. We're thrilled and honored to have our beloved Dean, Erwin Chemerinsky, to say a few words to kick us off today.
Good morning and welcome to Berkeley Law. As everyone in this room knows, racism infects every aspect of the criminal justice system. That's why the Racial Justice Act of 2020 is so important in trying to deal with racism in charging, convictions, and sentencing, and it was strengthened in 2022. But it's time to look at it, to assess it, to better understand it, perhaps you need to think about how to strengthen it. So I'm so very grateful to Chesa Budin, who's the director of our Center on Criminal Justice Society, for putting together this important conference. We have, I think, 500 people registered in one way or another to be part of it. We have an enormous number of the state public defenders here. And this is exactly what I wanted the center to be when we created it. And I'm so grateful to Chesa for this conference and for all that he's doing. It's special to have you here at Berkeley Law. If there's anything that the law school can do to help, to make your stay more comfortable, please let us know. I also want to thank Tony Mendocino, who's done so much to help with regard to the planning of this conference. I know that no one comes to a conference to hear the dean's welcome, so I will keep it at this. I will simply say, welcome. Thank you for all the hard work that you do every day for the criminal justice system, and thank you for your attention to this incredibly important law and all that it's doing to improve racial justice in the state of California. Thank you.
Good morning, everybody. I'll go ahead and get started as the team gets on stage. It's wonderful to have everybody here. And it wasn't that long ago that I was sitting in the audience in a conference when someone said, there are people in prison because of a data problem. They were talking about good time credits that had been miscalculated, but no one could tell because they lacked access to the data until an auditor was able to get in and spot the problem. As a person lacking experience with the criminal justice system, I was stunned by the revelation that red tape and lack of data was literally keeping people incarcerated. Until I kept seeing it everywhere I turned. Headlines about prison overstays, the poor administration of resentencing, about difficulties in reenfranchisement, and in the realm that I'm most focused on, that millions of people, tens of millions of people, were not getting their criminal records cleared and were staying blocked from jobs, housing, and economic opportunity, all because of the poor data and poor administration of relief from the criminal justice system. I'm Colleen Chien. I'm a professor at Berkeley Law that joined in the fall from Santa Clara Law, and I founded the Paper Prisons Initiative 5 years ago in order to address what I call America's paper prisons, the gap between eligibility and delivery of relief from the criminal justice system due to problems in data and administration. Let's see if the slides actually are showing. Okay. We're a dedicated group of academics, students, and volunteers that does rigorous empirical research to bridge the gap between eligibility and delivery of relief from the criminal justice system, with current projects in the realm of expungement, driver's license suspensions, and the RJA. But we also try to produce tools and data to empower people like yourselves who are in the trenches doing the hard work to try to make sure that the research actually brings impact. Now, many of us are not criminal law experts. That role is played by people like Professor Paul, but most of us have worked with and understand data and tech as empirical researchers, data scientists, and software developers. Over the next hour or so, we're excited to share a data tool we've been working on for several years that we hope can address the gap that much of today will be devoted on, how we can make the promise of the Racial Justice Act a reality. Just by way of a little bit of background, passed in 2020 in a deliberate departure from the Supreme Court's jurisprudence, the Racial Justice Act introduced a novel new standard for proving actionable racial disparity, allowing for relief, even absent a showing of intent to discriminate, when the totality of evidence demonstrates a significant difference in charging, conviction, or sentencing across racial groups when compared to those who are similarly situated and who have engaged in similar conduct. Evidence of significant differences among races and similar situated defendants can be proved at 3 different stages. If good cause is shown, the defendant can get discovery. Under 745C, if a prima facie case can be made, then the defendant can be entitled to a trial court hearing. And finally, at 745E, if the violation is proven by a preponderance of the evidence, the defendant can get a remedy specific to the violation. As you'll hear later, the data that we have access to is comprehensive, but it's limited. And therefore, we think the most appropriate stage where it might be useful is at this good cause showing stage. As the Young versus Solano decision states, the standard of proof at this stage is modest, that a plausible case for disparity, not a strong one, be made. In that case, statewide data and data from a county other than the defendant were sufficient to show good cause. But while we think that this tool can best be deployed at the initial stages, we believe that it may be helpful to defendants in all stages of their prosecution and incarceration. We have a paper that explores the new test and what it does and doesn't mean, including in light of similar racial justice acts in North Carolina and Kentucky, and attempts to apply this from the perspective of the Corey data that can be accessed at our website. But today we want to talk about our tool which, pending approval from the Cal DOJ, will put the data in your hands so that you can explore the state of disparity at the county offense, year, and race level. A dummy data version of which you can now access at paperprisons.org.rja. I'm now excited and delighted to turn it over to our lead developer, Akhil Raj, to talk a little bit about himself, why he joined the project, and about the tool.
Good morning and greetings to all. My name is Akhil Raj, and I'm excited today to be with you all and be your guide for the walkthrough of the Racial Justice Act tool. Now, before we dive into the discussion and the walkthrough, let me tell you how I became part of the project. So, while pursuing my master's at Santa Clara University, I had the opportunity to work with the Northern California Innocence Project at Santa Clara Law. While working with the individuals at NCIP, I witnessed the profound effect that the team had on the lives of people who were seeking justice. And post my graduation, I had the wonderful opportunity to continue to do so by joining Professor Chien's Paper Prisons team. Now, moving on to the application. Our application has been, You'll find that the website is not just a digital presence. At its core, the tool is designed to provide an insightful and interactive experience.
There you go.
Okay. Starting off with the navigation links at the top of the application, you can see these links have been provided for the user to jump across different sections of the website and familiarize themselves with the terminology and the methodologies that we are using for representing the data. The user can navigate to different sections. And then moving on to the chart, The pivotal element of this tool is the dynamic chart that we have provided to represent the data. The chart serves as the focal point for representing the data that is both comprehensive and user-friendly. Now, we understand that all the users have this specific focus area and interest. So that's why we have provided these filters. The filters, meticulously provided, help the user to tailor down the data to their needs and preferences. Let me walk you through a scenario and tell you how the tool works. So first of all, starting with the years, currently we have a data set that spans across from 2010 to 2021. So the user can select either the data for all the years combined or individual years. And then we selecting the county. So here the user has the option to switch between the 58 counties of California or show a combined all counties data. Then the event point, wherein the user can select whether at which stage of the charge was they want to see, and moving on, the race. And offenses. In the offenses, the user can look up the offenses based on the PC code, or just type the name of the offense. And then filter out the data. Apart from that, we also gave an option to print the data, and so that the user can have a pictorial representation in the form of a PDF, view the data in tabular form, or download the data as an Excel sheet for future reference. And now Professor Chien would be discussing in detail about the measurements. Thank you.
Thank you, Akhil. And thank you for all your work on the tool. So we're going to walk you just through one county, one charge, but some different measurements that are provided by the tool. And hopefully you can still see this. I'm making it a little bit smaller. But one thing that we do is try to provide different options for the user to look at different levels of disparity, whether it be measured with reference to a particular ethnic group or with respect to a particular event point or the population in general. So we pick Los Angeles. We'll see that this pops up for this period of time. And I think we picked burglary here. And we picked all the different ethnic groups that we have right now coded in the tool. And you see that the numbers can be quite small for certain groups. And so if you look and filter for smaller numbers of years, you may get to a situation where you don't have sufficient quantities to actually be displayed in the tool. We'll talk about that a lot more. But on the measurement side, you can also see what flexibility that the tool affords. Right now, what you're seeing is raw numbers. And when you look at this, it looks like Latinos are arrested at the highest rates during this period of time. Each person represents 10,000 adults. But when you actually look and filter to look at the rate per population, the story changes. You move from Latinos being most overrepresented to blacks being most overrepresented in terms of their racial disparity compared to the representation in the population. And the methodology section walks through specifically, and Bill will walk through as well today, how exactly these measurements are calculated. We start to look at rate per prior event point, and then we can see that some of these disparities become smaller because the question is conditional upon getting to arrest, what is the charging rate, et cetera. And so those comparisons can be made. Similar metrics are looked at with respect to disparity gaps, since disparity is the focus of the RJA. So disparity gaps per population. Again, you see this large disparity in terms of the black population, just completely off the charts, and it gets stronger as we get more to move through the prosecution. And then finally, we see disparity gap per prior event point, which is similar to the other metric. As Akhil mentioned, the data can be downloaded, and I'll just show you how that can happen. Once you pull the data up, then it will contain not only a privacy notice, but the data itself, and then it will also, in time, have a data sheet which will explain the data and allow you to just get a summary of what exactly you're seeing. So I'm going to turn it over now to Bill to walk us through some of the data and answer questions that you might have about it.
Great. Well, thank you, Colleen and Akhil, and thanks to CHESA and UC Law for pulling us together. It's really an important event, and I'm happy and honored to be here and talking about this interesting tool. Just very quickly about myself, my name is Bill Sundstrom. I'm a professor of economics at Santa Clara University. Started working with Colleen many years ago on some earlier work related to this project. My interests are mostly in the area of economic history of racial disparities in the U.S. labor markets, but I've recently gotten really interested in just how data analysis can be applied to a variety of sort of modern policy questions. So I come at this as kind of an empirical economist type, and it's been very interesting to think about how we can adapt thinking about data and analytically about empirical issues in a way that can inform actual practice. Those two things are sometimes at odds. I'm going to say a little bit about the data set that we are deriving all these statistics from, and then I want to try to link back some of our measurements to the terms and standards of the Racial Justice Act in terms of significant difference and similarly situated and similar conduct. If there's sort of a question of clarification that occurs to you while I'm talking, do please raise your hand, and I'll try to leave a little bit of time at the end of what I'm saying to answer any other questions about the data analysis or the conclusions. So the data come from the California Department of Justice CORI data set, Criminal Offender Record Information. Basically, that's the state's assemblage of a rap sheet type information across all the counties in the state for a long period of time. I'm not quite sure how far back the electronic records go. We're really focused on the since 2010 period, but we know it can go back further. The data that we are using are anonymized. They contain no personally identifiable information, and that's one of the terms of our data sharing agreement with the state. We're focused, as Colleen showed with the tool, on penal code offenses and arrest and court events. The data set is rich in a variety of other sorts of things that can happen that it records, but we're really focused on arrest events and sort of the subsequent sequence that goes through the cycle of the court system. The raw data that we process for this contains about 28 million rows. Each individual may have many rows because there are many events that happen and then potentially a number of incidents. And I think Akhil already showed you sort of the event points that we focus on: an initial arrest, charges filed in court, then a conviction, and in particular the subset of convictions that are felony convictions, and any prison sentence. And our prison sentences don't include suspended sentences in the way we've defined it in this data set. You know, those are further refinements that could potentially be added in version 3, 4, 5, or 7. I want to say a little bit about some of the details here. Offenses, I just want to be very clear, we are defining offenses at a fairly granular level. So as it says there, the PC code subsection. But even within those, there are a lot of ambiguities and complications, and so you know, we're thinking through ways to possibly enrich the set of the way we classify offenses in the data. But at this point, that's what it looks like, and again, the events that I mentioned there. I want to say a little bit quickly about the racial categories in the CORI, and we are going to, of course, put those relative to population figures for the various counties. The CORI records a single mutually exclusive racial category, and it has a whole lot of categories, but you get assigned to one. I would love to talk to people about how they think those categories are assigned to people, whether they're elicited or are put in there in some way by the arresting authorities, et cetera, but you get one race, and that's that. We have to compare that with data that comes from the Census Bureau. That's the American Community Survey. So when we see those per population or per 100 population numbers, we are looking at the county overall populations by race and ethnicity. The categories are not strictly comparable. I'm sure everyone's aware that this is a complex and ambiguous area in social science and society, of course, at large. These are the correspondences that we are using. And one thing about the census data, of course, is that the race ethnicity categories are not mutually exclusive. You can be Black and Hispanic Latinx. You can be all sorts of mixed races. And we have tried to do what we think is a fairly common sense concordance across the race categories. In particular, for the white race, which is just recorded as white in the data set, we assume that they mean white non-Hispanic, since they have a separate category for Hispanic. So that's quickly about the race categories. I think I don't need to say too much about this. This was already discussed a little bit in the tool, but we really have these population comparisons, the rate per 100 population, and then the gap between any given race and white non-Hispanics. And then we have the rate per prior event point. And I'm going to refer back to this and ask the question whether looking at rates between racial groups, once we control for the step of the process they've gotten to, that conditioning process, whether that indicates something to do with similarly situated or not. So those are our sort of 4 basic metrics. As Colleen mentioned, you will sometimes pull up a number in the tool and get an NA, and the NAs, for the most part, arise because under our data agreement with the state, DOJ, we have agreed not to report any numbers for which the breakdown has 10 or fewer individuals of either race in the comparison. So that actually ends up, when you narrow it down to these counties and offenses, to be a significant restriction on the availability of data. So we'll talk a little bit about that. Otherwise, we don't say much about significant difference. I think everybody would expect an economist to come up here and start talking about p-values and confidence intervals and all that sort of stuff. You can read our paper, and David will say more about what kinds of metrics are useful or not. But we eschew that here and want to leave it to the practitioners to think about what they think a significant difference entails. The RJA language says that we care about significant difference. That does not necessarily mean the same thing as statistically significant difference, right? Which is what we would, with a standard we would use in social sciences. So those are questions that I think are going to evolve as practice evolves and precedents evolve. Similarly situated, for us, we have limited ways to sort of ask the question whether we're comparing people who are similarly situated. And our main sort of way of slicing the data is by county and by year. So we're looking at people who are, in that sense, they're in the same county and situated similarly there. At this point, we do not condition on, for example, criminal history, prior convictions, etc. This is something that can be done with the data, and I think it's an open question whether that's an appropriate way to condition the data and identify similarly situated, particularly because it doesn't necessarily take account of the process, which is likely to involve disparities by which people arrive at a particular place or event. Similar conduct, our major way of approaching similar conduct is very crude and again subject to criticism, which is that we stratify by offense. So that's about it. We have very limited information in the data about other aspects of conduct that are associated with the offense being accused. So that's a definite limitation in the data. I want to just reiterate, and I'll leave it mostly to David to talk about the pitfalls of getting too concerned about or the pitfalls of doing the wrong thing to control for similar situation and similar conduct. As we know, the process is sequential and cumulative, and if arrests are involve a high degree of disparity, we end up with a set of people at conditioning on arrest who go into the court system with who are not really comparing apples to apples or oranges to oranges, but may have a whole set of historical events that reflect bias built into the system prior. So we need to think about that, and I think that's why we, partly I'm going to show you some numbers based on the population comparisons, which at the very least tell us something about when you get to the point you're at, how does your representation there compare with your representation in the population at large. So I want to just turn briefly to a couple of little sort of case studies involving kind of potential applications and issues in our tool for the Racial Justice Act. The first one is going to say a little bit about, how broad is the reach of the Racial Justice Act if we're going to try to look at statistical or data-based evidence, and this is going to bring us to this small numbers problem that we encounter. The more precise we make our comparisons in terms of offenses, counties, years, possibly other ways of stratifying the data, if we moved on and talked about priors, for example, we narrow our sample sizes, and as we move into the less populous counties of the state, we find that there's a lot of these NAs that pop up, and I'll show you just a little evidence on that. So there's a kind of a trade-off in this, and we'll talk at the end about some potential ways to work around that. The second sort of case study that I want to note, which is a little bit more promising, is sort of how to think about some ways to use a tool like this, not to decide cases, but possibly to present a good cause case, for at least for discovery. And one of those might be looking back at folks who are currently incarcerated and asking the question, how many folks might be subject to some kind of remedy based on an RJA claim. And I don't have an answer to that, but I'm going to bring to bear just a little bit of suggestive evidence we can get from the tool type data. All right, so let me turn quickly to this question of sample sizes, and I already noted that as we slice the data and refine the comparisons, we are limiting the number of cases that we can examine, and this is a huge problem in our data set, especially for small counties where there aren't many people, and for uncommon offenses. Bear in mind that what I'm going to show you is the number of cases that satisfy our N greater than 10 criterion, which we've agreed to with DOJ. Now imagine if you were a social scientist and you're saying, I want something that's going to establish a little bit of power for statistical significance, then we might be thinking more in the lines of 50 or 100 N for comparison, and that's going to just not be possible in an even greater number of cases. So this is just, I've got to throw up a bar chart that's illegible because otherwise I wouldn't be a practicing economist. So you have to squint your eyes. I'll tell you what this says. It's really more to just kind of give you a visual. This is the percent of arrest incidents in our data in 2018 with samples greater than 10 among black defendants. Okay, so this is the 100, which you can see up where it says Los Angeles at the very top left. That would be if all the cases passed the hurdle of sample size of 10, right? So LA almost makes it, and San Diego next, San Bernardino. And as you move across to the right, you're getting basically, I've ordered the counties, county by county, and in terms of this percentage, and by the time we get down into maybe the smallest third of counties by population, this has really dropped off, right? So the N greater than 10 threshold just is going to give you a lot of NAs in small counties. This small county problem is something that if we're going to adduce statistical evidence under RJA, we've got to figure out ways around that, maybe by aggregating across counties or something of that nature, and we may say a little bit more about that. Here is the percentage of felony conviction incidents in 2018 with samples greater than 10 for black defendants, and this is even more dramatic because there's just fewer of those felony convictions than there are of arrests. So once we slice down to a less prevalent incident, we now find that over half the counties just drop out in terms of meeting the data threshold. So just want people to be aware when you go into this tool, we think there's lots of stuff of interest to get out of it, but especially if you are a PD in a small county, you may encounter some disappointment in terms of how much actionable data we have, and that suggests relying on quantitative evidence is going to be easier in some places than others for sure. Here is arrest incidents for Native Americans. This is analogous to this first chart for black defendants, and because the population of Native Americans is that much smaller, we have that much more of a data problem. Okay, so it's something to be aware of. Just turn quickly to this second sort of case study of potential applications and limitations of the tool. One thing that Colleen raised of interest that comes partly from kind of requests that we've gotten ad hoc from people who might have cases or cases for relatives is could we apply some tool type evidence to making cases for habeas cases of folks who are currently incarcerated under convictions that might have been subject to RJA claims. Again, our evidence can be a pretty crude hammer for figuring out, you know, as a tool, it's not a fine drill bit, but a hammer for sort of looking at some broad statistical evidence. One thing that we can do is sort of ask the question of all the folks who we don't have incarceration data, we don't have corrections data, we have prison sentence data. So if we look at the folks who received prison sentences in our data set and ask the question, you know, how many folks who received a prison sentence did so in a county with, and on an offense with a disparity gap that was large against their race, that would be what we're sort of portraying here, right, relative to whites. So that gap, that disparity gap, if it's bigger than 1, that means your group is has a negative disparity, and if it's 5, you know, you're relative to population, you're more than 5 times as likely as a non-Hispanic white defendant to be experiencing that event. I'm not going to, you know, dwell too much on the numbers here, except to say that that last column shows sort of how many folks in our data set over a period of about 10 years, this is a 10-year sort of pull, are in this situation where their sentencing occurred in a county with a disparity gap greater than 5. And you can see for black defendants, this is the overwhelming majority of those cases, 43,000 folks in that state of affairs, and very large discrepancies. The gap less than 1/5 would be a discrepancy in the other direction, and you can see that for the most part those are quite rare, sort of the white favoring, sort of minority favoring discrepancies. So how am I doing on time? Good? So I'm going to leave it at that. I know I covered a few statistics and a lot of bars on a bar chart in a brief period, but I think it would really be helpful to us to get some of your questions about the tool, any of the data choices that we had to make. As you might imagine, the data are not clean and stuff doesn't fall into your lap. You have to do a lot of processing and making of decisions about what counts for what. But we've tried to do that in a sort of reproducible and good faith way. So I thank you for your attention and open it up to a few minutes of questions. Yeah.
When I look at similar data for Orange County, there's a lot of blanks for race and a lot of what I would assume are actual Hispanics listed as white. Is that something that you've been able to address at all?
I would say we don't have many blanks in this data for race. It's all pretty filled in, but there are quite a few others, or unknown. So I guess unknown is a blank, right? So I can't recall exactly what fraction that is. Certainly most, you know, people, the race is identified. I think the question of, you know, what race a Latina person is assigned to is going to be an issue, and we don't have any independent way based on these data to assess that. There are a lot of people listed as Hispanic in the data set, whether that's an undercount and that some other folks who are of Hispanic heritage would be identified in there as white. I don't have a good sense of it, and it's certainly something we need to.
in the paper that was done in Texas, where there was a similar problem where they felt like police were reporting misattributing races in order to increase the hit rate on white people and to decrease the sort of charges of racial profiling. And so, but I'm happy to share that with you afterward. That might give you some insights and a workaround for that.
But we're happy to add in our documentation what the missing data rate is by county so that you have that information.
Yeah. Version one of so the question, if you didn't hear, was, can we with the tool look at potential racial disparities in plea bargaining, both say bargaining down charges, et cetera, especially between going from the arrest to the charging stage. The tool version 1.1 or whatever we're calling it now does not. That's a complicated process. We do have presumably the data that would, we don't know whether, it sometimes tells you whether there was a plea bargain, so, and when it talks about the way the disposition is categorized in the data, but I don't think always. But we can certainly look at, for any given cycle, for an individual, what happened to the set of offense charges moving from arrest to court. And so in that sense, and this is something I'm planning to work on, is if we can categorize, say, the severity of the charges, can we see whether bargains or whatever else, prosecutorial discretion that leads to an offense declining in severity, whether there are racial disparities in that. And I agree with you, it seems like a very important question. From a data crunching point of view, it's a little complicated because you have to have some assessment of, there's so many offenses. If it goes from this offense to that offense, I need to know, is that a positive shift or a negative shift for the individual. But in principle, it could be done. Yeah.
What's your confidence level in the uniqueness of the data and what assumptions are you making for any poor reporting habits from the lower levels of reporting?
I wish I had a really good answer to that's a great question, the confidence level, and I think there's the reporting at the different levels, and then there's also the different counties, right? And how the county shifts its data into the DOJ repository, and what are the data checks on that? I don't really have a good answer to that. That's certainly something, my feeling is that there's already enough sort of noise in the data, whether it's from the racial definitions to the kinds of reporting out at different levels, that I think we're really looking for broad patterns and big disparities as the sort of most reliable thing that you can get out of this, I would say. Yeah, back there.
How's the tool handling situations where somebody's charged or convicted with multiple offenses rather than just a single one?
Yeah, so that's a very good question, and I was not clear enough about that. We, in the tool, we stratify, so the unit of analysis in the tool is an incident by offense. So you get, and an incident is what the data call a cycle, right? So a cycle, you go in, you might get charged on multiple offenses at the arrest level. We take each of those offenses as a separate row in the data, right? So a given individual for a given incident might be reported for several different offenses in our tool. So one thing to bear in mind is this is not a tool that reports numbers of individuals, it's numbers of incident by offense units, right, in the data.
Is it distinct per person, per case, per offense? So if somebody's got 3 robberies, is it going to show, in the same case, is it going to show up as 3 rows in the data or just one for that?
No, we collapse, if you got 3 counts of burglary 459 on that incident associated with that arrest, that's going to show up as one row in our data. Now that's an interesting question, right? If you get charged with multiple counts of an offense, that presumably may be worse than getting charged, obviously, with one count of that offense, especially if it goes through to the end. And we have just made the decision at this point to collapse that to one unit of observation. Yeah?
Does the tool have the ability, does the user have the ability to select multiple, like can we compare like all theft offenses? Can we select multiple offenses and have it all show up on the same, black defendants charged with theft offense, for example?
Can you repeat the question for folks on?
Yes, I'm sorry. I should be repeating the question. I should know better.
Or folks can come and use the mics up here.
Yeah. So the question was, can we, I'll say the previous offense was, the question had to do with whether we count sort of multiple charges on a given offense as, 3 counts, separate rows in our data, and we do not. We count, that was the collapsing question. The question over here was, can you basically aggregate and combine offenses so that you get the whole set of theft offenses or, violent assault offenses or what have you, collected together and of course that would be a nice way to get around some of the sample size problems. Current version does not have the facility to do that. I think we're going to move on and have some of our students talk about some of those kinds of augmentations that we're hoping to put into later versions. Yeah.
Maybe we can transition to them, and then
Yes.
we can take questions at the end.
Yeah.
Okay.
Do you want to
So
introduce
yeah, I'd like to
these
have
guys?
Rayna and Bennett
So I'm gonna-
come up and talk a little bit about what we're planning to do with the tool. But we can continue asking the questions after the presentation is finished.
Great. Hi, everyone. My name is Rayna Saron. I am a 3L here at Berkeley Law. I also got my undergraduate degrees from UC Berkeley in cognitive science and legal studies, where I was lucky enough to work with Professor Jack Glazer, who I believe is here today and will be speaking later, conducting research on implicit racial bias in policing. I've been helping with the later stages of tool development and beta testing. I've also worked at a handful of public defense offices in law school and will be with the Alameda County Public Defenders after graduation. Oh, thank you.
And my name is Bennett Cyphers. I'm a 2L here at Berkeley. In a past life, I was a computer science major, and I worked at the Electronic Frontier Foundation. Now I'm working with Professor Chien, doing basically the same thing as Rayna, just some later stage development under Akhil, and I'm also externing at the Contra Costa Alternate Defender Office.
So we had some questions about tool functionality, which segues nicely into what we see as our next steps. As folks have mentioned, the tool that we have hopefully releasing soon, pending DOJ approval, is just V1, and we do have plans to increase functionality, one of which is combining various variables like offenses, being able to customize, pick and choose what offenses you want to combine together, as well as potentially having broader categories like theft offenses, gun offenses, et cetera, and also being able to combine years. Currently, the only option is to select a single year or all years in the range that we have data for, but we want to add users, give users the added flexibility of selecting multiple years. We also hope to incorporate additional filtering options, so adding in further variables and ways to slice the data, potentially age, gender is an area we do have the data on already, as well as prior criminal history, again, to potentially help with the similarly situated analysis, as well as general performance improvements, keeping load times down, and having dynamic error messages, so if you do get a lot of NAs or no data, you can have some pointers on where to go next. Another bucket of expansion that we're hoping to implement down the line is just expanding the data that is within our tool. So as you all have seen, the data range we have is from 2010 to 2021, but we have approval to actually include data from all years in the query data set, so both expanding the prior years as well as...
We don't have approval yet.
Oh, sorry, we have access, not yet approval. But that is something that we hope to implement, and also updating the tool with more recent data. And as Bill mentioned, we don't have any information about sentencing length or suspended sentencing, so potentially getting that data into the tool is one area of expansion, and potentially also more racial categories, breaking down potentially the Asian category into more subsections as well.
Yeah, so as Rayna was saying, a lot of the near-term improvements we're working with are just trying to get the data that we have access to into the tool and reflected in the tool in ways that will be useful to people using it. Longer term, we want to see if we can incorporate other data sources, perhaps, to sort of fill in some of our gaps. We want to look at, trying to get priors, being able to filter by priors, because we know that's going to be a big deal for similarly situated, perhaps sentence enhancements down the line. And so as we're releasing this tool, what we want from all of you in this room is feedback, early and often. So this is version 1. As you can see, we've talked a lot about its limitations. We hope it will also be useful in a lot of situations. And we'd love to hear both sides of that. Like, if you use this tool and it's useful, we would love to hear about it so we can figure out, how to make it more useful and how to get the message out to more people who might be able to use it in your situation. If it's not useful to you, but there are tweaks that we could make to make it useful to you, please tell us. If it's not useful to you at all and you're afraid, that it might be useful to the DA, we'd like to hear about that too. And we also want to know, as this starts getting put into practice, like how does this fit into the RJA law as it develops? Like, what are judges looking for? What kinds of stories do you want to tell with this data? And how can we help you tell those stories? And finally, if you are working on something similar, if you're working in data at all, if you're working on collecting data, aggregating it, digitizing it, or visualizing it in some other way, we'd love to get in touch and hear what you're working on, see how we can work together, avoid stepping on each other's toes. And we want to make this just sort of find a niche in this ecosystem where we can be as useful as possible with the resources we have.
Thank you guys so much. Some of the amazing Berkeley Law students that are here and that have had previous experience with the PD and are going to be here. So we'll be here during the conference today. If we don't get to your questions, please find us. We'll also put up an email address that you can send messages to. So I'm going to have David Ball now talk a little bit about reflecting on this and also where we go next.
Yeah. So everyone, I just jiggle around. Okay, jiggle it around. Yeah, everyone here came for some epistemology / history of statistics, right? But these questions that I have behind me are really important because our ultimate question is, what does the data mean, right? So we've seen some numbers here on racial disparities, and I bet that most of you don't think that in 10 years, when they turn into criminal history, right, that those numbers are suddenly going to turn into race-neutral reasons for racial disparities. Okay, so I'm here really, I want to talk a little bit about what race-neutral reasons might look like for disparities, but mostly to say that it's really important for us to have a theory, and the theory that any of these criminal justice data are race-neutral, right, is itself an assumption that needs to be justified. Okay, so you need to have a theory about why system data aren't affected by race, because the numbers don't speak for themselves. So I'm going to just have 3 sort of separate points here. First, I'm going to really talk about what I mean when, or what it means to say that all data are theory-laden. And second, I'm going to talk a little bit about race-neutral reasons with a focus on criminal history. And third, I'm going to argue why I think it's really crucial when we articulate, when people come up and say, well, the numbers are reflective of different racial patterns of offending, that it's very important to say, why is that? What's your theory behind that? Be explicit about that. So first, the question of what these numbers mean now, right? My approach here is, sort of what's called Bayesian analysis, and don't freak out. That's essentially the legal question that all of you are used to dealing with, right? Given what we've observed, what does it mean? What do we think actually really happened? What's the causal story behind it? What kind of causal inferences can we draw from correlations? Because these are all just correlations, right? These people of these races are correlated with these system outputs. So to give like a very non-political example, you know, the Niners came back from a halftime deficit last weekend. I watched the first half with my criminal law godfather, Bob Weisberg, and the second half with my older son when the Niners started coming back, right? That's correlated with their comeback, but it doesn't explain it. And we're pretty confident in saying that because there's not a theory of the outcome that involves the location of one particular fan, right? You can't devise a test for my mojo. Although that's not going to stop me from doing the exact same thing during the Super Bowl. But, you know, we reject this explanation because of our background knowledge about how the world works. And all of you, even if you're not data scientists, have lots of background information about how the criminal system works. Okay, so to go to data that my co-panelists have presented, right, we can look at these correlations and have multiple explanations for why they exist because the data can fit multiple theories. There's not one way to read it. There's not something that the data says. It depends on the choices we make in our comparisons and in the model of the world we bring to it. So is this evidence of a race-neutral system or a race-inflected system? If it's a race-neutral system, the explanation could be that differential rates of arrest, charges, et cetera, reflect actual differences in the behaviors of people of different races. If it's a race-inflected system, then differential rates could be the result of system artifacts. So choices about policing, choices about charging that are a result of the behavior and structure of the criminal legal system. So one says police arrest more black people because more black people are committing more crimes. One says police arrest more black people because they are black, and there are intermediate rationales. Of course, people commit crimes because they're poor and there's a black-white wealth gap. People commit crimes because they have no gainful employment and there's a black-white employment gap, et cetera. The fact that both of those explanations are possible explanations don't make them equally plausible in my view, but the point here again is that there isn't a single theory that is true and neutral and another theory that is not true or political, right? The explanation that race drives offending is not somehow apolitical and objective, and the explanation that systemic treatments drive disparities is not somehow political and subjective. They both require justification. We're actually trying to figure out what the best explanation is, not say, well, the system is justified as it exists, right? So if there are, I'm saying this because once you get discovery, you're going to come across people who say criminal history is the reason, right? And we could also ask this of our initial comparisons, and I think that's implicit in sort of some of the questions that Bill was having. You know, Bill was getting is, what are similarly situated individuals now? Right? Like what constitutes something besides race that makes someone similarly situated? So ideally we'd have like a white person and a black person doing the exact same thing at the exact same time under the exact same circumstances with the same officer, and one gets arrested and another person doesn't, right? The white person doesn't. But we couldn't infer that from the data that we have because if there isn't an arrest, we don't have that in the data. So we might even ask if arrests are relevant comparators. They are if our theory is that arrests are race neutral and that we detect crime and punish it in a race neutral way. But if our theory is that arrests aren't race neutral, arrests are not relevant comparators. And which of these is more plausible depends on your underlying theories. I give credit to some large-scale studies that looked at New York City's stop and frisk program to conclude that I don't think arrests and stops are race neutral. I know this is California, but I'm happy to lay out why I think that arrests and other data aren't race neutral. But the larger point is that I should have to justify that, but so should someone who's arguing that arrests are race neutral. Both theories can explain the same data, right? We have to rely on our theories of how these data explain the world. And the reason why this is important is that in the United States, we used to have explicit theories about how race caused crime, which Khalil Gibran Muhammad details in his book, The Condemnation of Blackness. Statistics departments grew out of eugenics departments. There was an avid academic belief that race explained social outcomes causally, including criminal behavior, and I would argue the effects of that are still with us, sometimes explicitly, as in the work of Charles Murray, and sometimes implicitly. And we really need to be careful that we don't just lapse into these implicit associations about race and crime. So if we were to say something like, that let's say we did believe that there is a race-neutral reason for crime, then we have to have a theory about why race causes crime. Okay? So is that biological? Like, what's the causal mechanism from melatonin in the skin to criminality? And how does that fit with the existing scientific literature on human behavior? When I tan in the summer, do I get more violent? Do some people who are perceived to be Hispanic have more melanin than some folks who are perceived to be white, although that's not always true. But we don't observe many discrepancies in the data between people identified as white and people identified as Hispanic. So what is the dose response curve of melanin to crime? It's clear that it doesn't just increase linearly. So why is that? And what's the relationship between so-called Asian races and crime? If it's racial, wouldn't we expect to see similar rates of offending among, say, people of Chinese descent in the US, Malaysia, Indonesia, Taiwan, and the PRC? Do we do that? It's not an answer just to say it's cultural, because it raises questions about how culture operates. What are the definitions of culture? What are the cultural variables that we can isolate that lead to criminality? What are the features of white culture that lead to non-criminality? Or maybe, as seems more likely to me, the role of culture is the way the dominant culture treats people of color. So some alternatives to race, which are to race neutrality, or alternatives to race-inflected systems, which are plausible, are just other examples of racial marginalization, right? So race is correlated with poverty, and poverty drives crime. Race is correlated with policing, and policing results in arrests. These explanations explain racial disparities not because race drives the way someone behaves, but because race drives the conditions in which someone lives or the governmental response to those behaviors. So really, what I want to leave you with is this, and it is governed by some conversations I've had with some of you individually and as groups. You have theories about why the criminal system works the way it does, and that's relevant. There isn't a way in which just because there are numbers that your expertise doesn't matter. It does. It should fit in with the way you've seen things operating. Data is part of the equation, but it is not the full equation, right? You need to look at these arguments, you need to look at the numbers and then make causal arguments about those numbers. And really importantly, if somebody is saying, we know this is race neutral because look at this person's criminal history, we know this is race neutral because this person has been arrested a number of times, it's incumbent on them to explain why that's not related to the cultural fact of race, but to something else. Okay? Thanks.